So obviously, when you're dealing with a public company, there's a tremendous amount of information that's available publicly because public companies are required to file their information, and that information is available to shareholders. But notwithstanding the fact that this information is available publicly, most buyers will require diligence of public companies, and so that's really it provides a lot of leverage to the target board, because there's always this option of going hostile, of bypassing the board. So it's very important at the front end that the board is not just giving away the confidential information, because while protecting it from a confidentiality standpoint is important, it also wants to make sure that it has some control over the process, that the buyer is engaged with the board and doesn't bypass the board. And so the typical price for gaining access to confidential information of a public company is that the buyer has to agree to a standstill provision. And a standstill provision is a provision that prevents the prospective buyer from making any acquisition of shares, because obviously those shares can be purchased on the public market. And it would also prevent any solicitation of proxies, for example, in connection with a meeting. So there's a whole host of things that would effectively lock down the buyer and require it to engage with the board. The standstill also serves another purpose in connection with auctions, because it facilitates the buyer putting forward the best price possible, because the buyer understands that with this standstill, there's not going to be another opportunity for it to propose a higher deal, right? Because remember that in a public company deal, the board will negotiate a so-called fiduciary out, which will allow it to take a better offer. So without that standstill, the losing party could then put in an offer after a deal has been announced with the successful party. So, looking at the different perspectives in negotiating a standstill, the target will obviously want to negotiate a very broad package of standstill prohibitions, and so there are some examples here on the slide. So they would include, prohibiting the buyer from acquiring any shares, any assets, any solicitation of proxies, any influence of management, and even prohibiting the prospective buyer from making a request to do any of the following: a request to waive the standstill. From the acquirer's perspective, it's important that the standstill only be operative if confidential information is actually provided. That may sound obvious, but there was actually a case a number of years ago out of BC where two parties entered into a confidentiality agreement. One of the parties decided it no longer wanted to have any negotiations, provided no confidential information. The other party made a hostile bid, and the target was successful in having that hostile bid effectively terminated because of the standstill. So there's careful drafting to make sure that the standstill only works if confidential information is provided. One of the other provisions that a buyer would typically want to negotiate is a so-called spring of the standstill. So this is a provision that says, okay, well, notwithstanding any of these prohibitions, the standstill won't apply in these circumstances. And one of the circumstances being that the target company has signed up a transaction with another party. An acquirer may want to go further and negotiate a spring that applies in the event that there's a hostile bid. so that if the theory being that if the target company is now in play, that everyone should be able to lob their bids in. It used to be the case that targets resisted these springs, but as a result of some case law, it's now the case, and I certainly take this position, that targets are better served by negotiating a spring, because what will happen is when you negotiate your support agreement, one of the deal protection provisions that the buyer will request is that you not waive any standstill. And that is significant because now the public company board has effectively precluded its ability to accept a proposal from anyone that has signed a standstill. And so these are, the kind of the combination of the standstill provision plus that, prohibition on waiving the standstill is what's referred to as a don't ask, don't waive provision by the Delaware courts. And so I think while the standstill can be useful in facilitating getting the best price forward and allowing the target board to control the process, at the end of the day, you are, as a target board, restricting yourself from your options when there's a signed up deal. Yeah, especially if if the target board has if the target company has run a very thorough auction, there may be multiple standstills, and it's very important that that the target is consistent with the way the standstills operate. Because if your theory is that you want to use the standstill to generate the highest price, then you shouldn't have some buyers with a spring and some that don't have a spring. And so there was a very high-profile case a few years ago involving Sunrise, where there were actually two parties, two different standstills. The losing party that was subject to the standstill said, well, notwithstanding the fact that I've signed a standstill, I'm going to go and make an offer. And the successful buyer ultimately was able to have the court prevent that party from actually making an offer and having and also allowing the target board to consider that offer. And so it put the public company board in a really difficult situation, because there was this public transaction that was announced that was effectively an invalid offer, but all the shareholders knew about it and said, why did you foreclose your ability to accept that? So that's part of the reason why I think it's a better practice just to give on the spring, so that if there is a signed up deal, then the standstill falls away for everybody. I think it's a better outcome for shareholders. The other provision that that obviously gets negotiated is the duration of the standstill. The typical period is around 1 year, but you do see examples of periods that are longer than that and shorter than that. So this slide, I mean, we talked about the don't ask, don't waive standstill provisions and the benefit of having it and what that does to you. So in Canada, the case law is clear that it is acceptable for a board to constrain itself in this way. In the U.S., the law is unsettled, and so when you're working transactions with U.S. lawyers, they're more fussed about this point. This is just for your records. This would be a sample of a standstill provision. The last clause is restriction on even asking for a waiver. Sometimes you see a formulation where the party is permitted to ask for the waiver privately, rather than publicly, because there were examples where there was a standstill and then a party announced publicly that they had requested a waiver of a standstill so that they could make an offer at X dollars.